All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kaylin Cheatham. I would note that Mr. Cheatham's going to be late, so we'll wait for him to arrive at Sanctions Court. Jerry Kimberling. Guy McSpadden. Adam Wynn. Waiver of arraignment filed, approved. Pretrial has been set June 20th. Attorney on that case is Mr. Jason Castle, if the state's unaware.
Thank you, John.
Dennis Floyd. Sorry about that, Mr. Floyd. Samantha Nix. Samantha Carol Nix. Eugenio Gonzalez Merlo.
No, not present. We have Mr. Merlo, custody of Wallace County. We may have a resolution today. We can have a moment to discuss.
Sure, I'll recall it.
Maybe not.
James Godwin. I'll recall it. Trevor Blackman. Randy Chavez Torres, CR 2446, verified in Hunt County as of yesterday. I'll recall that, Manning. Joseph Hazel. Joseph Ryan Hazel. Jimmy Overstreet. Hudson Griffin. Christian Munus. Wallace Anderson.
Your Honor, client told me she's going to forget. She sent me a text message at 8 o'clock that she has traffic problems.
Did she tell you how long before she expected to be here?
Didn't jump back.
All right, I'll recall the case. David Shields. Larry Marshall. All right, the other two are for 9:50 and 11 o'clock. Do we have any attorneys that are ready? You may. This is on. Sir.
Judge, I gotta
You want this on the record off the.
take me off the record.
All right, for the record, cause number CR 23-140 and 141, State of Texas versus James Wesley Godwin. Mr. Godwin was set for final docket call today. In speaking with Mr. Hawkins, attorney for Mr. Godwin, as well as the state. Mr. Hawkins believes that Mr. Godwin may have been admitted into the hospital for some medical issues yesterday or today. The court will have his name called loudly distinctly 3 times. If he does not appear, the court will take a judgment on his side under advisement until tomorrow at 4 p.m. The court expects Mr. Godwin to produce some type of medical documentation showing proof of admission as to why he's not here today. Upon receiving that, then the court will reset the case. Let's go ahead and reset. Today is the 16th. Let's reset for status. Are you available on the 28th?
Yes, Judge, I am.
All right, let's just reset for final docket call and status on May 28th.
Is it 9 o'clock, Your Honor?
Yes, sir. Oh, yes. Yes, thank you, Mr. Hawkins. All right, do we have any other attorneys that are ready? Seeing none? All right, Mr. McSpadden. All right, this is a sanctions court hearing. All right, Mr. McSpadden, let's see. Last time you were in court, there was some things we talked about, ordered you to pay your probation fee, your court collection fees. I see that you did that. What I am needing from you now is I need to get you a substance abuse evaluation. I need you to take that by our next reset date. I'm gonna give you another date for sanctions court. And so these are the things that we're gonna get done before the next sanctions court. All right, we're gonna pay $60 to probation, $40 to court collections. I need 15 hours of community service because you've not worked any of your 450.
Judge, I actually got some hours done yesterday and I plan on, I got a place to go now.
Okay, good. Where'd you do your community service?
Food bank in Hawkins.
Okay, good. All right, so 15 hours of community service. I need you to take a substance abuse evaluation. You've got to take that with Mr. Chuck Jakes. I also need you to bring back the probation department provided you with a budget form and some other documents. I need that to be turned back in at the next sanctions court, as well as I need you to provide your medical documentation from your hernia surgery.
I turned all that in last time I was here, Judge. Everything except for I got the release form from the first surgery, but I don't have the actual document from the VA for the actual surgery itself.
All right, well, I want you to collect everything that you can and give it to your probation officer.
Yes, sir.
Okay, I'm gonna bring you back. On Tuesday, June 18th. 9 o'clock. And I need you to come over and meet with Ms. Burns before you leave, okay? So you'll sign that and then come over here and see Ms. Burns. extension for Ms. Kimberly. You come forward, please. All right, this is a probation extension, cause number CR 13-596-597 from Miss Jerry Ward Kimberling. Ms. Kimberling, why do we need to extend your community supervision?
So I can pay my fines.
Okay. Are you getting that done at this time? Are you paying your fines?
Yes.
And how much more do you have to go?
Right, 2,100, I think on one of them, and then I got 800 and something for probation.
Okay. And if we extend this an additional year, do you believe that will give you an opportunity to try to get those discharged without a motion or vote being filed?
Yes.
And Ms. Kimberling, are you the one asking for your probation to be extended? All right, nobody's threatened, forced, or pressured you to do that, is that correct?
Correct.
All right. All right, the court's going to extend Miss Jerry Ward Kimberling's probationary period in each one of her cases for an additional 1 year. Miss Kimberling, your extension period now, your probation period ends now on May 18th, 2025, okay?
Right.
All right, you want to come back here? I don't know. All right, come on back here, see Officer Matura, and then you're free to go. Is Samantha Nix here? Samantha Nix? Sure that we have the most updated info. Mr. Estrada, do you want me to call Mr. Gonzalez Merlo, or do you still need to speak with the state?
The state's waiting and hearing on from a response from this attorney. Your
Okay,
Honor.
that's fine.
We provided judgment documents, just down and sentence.
Okay, that's fine.
Yes,
You
Your Honor.
expect her to get back to you soon?
I'm hoping, Your Honor. how it looks over. I'm really confused. It looked blue in it, really good. That bluish, yeah.
You fix everything here quickly. All right, court's going to stand in recess, give the attorneys time to speak with the state. All right, we are back on the record. Mr. Schmidt, are you ready on your clients?
I am, Your Honor. Case Christopher Lucas and Hudson Griffin.
Who would you like to call first? Who would you like to call first? Hudson Griffin, CR 23-216. You may, it's Mr. Griffin. All right, this is cause number CR 23-216, State of Texas versus Hudson Kavanaugh Griffin. Mr. Griffin is set for docket call today. The parties have requested an additional reset. Board's going to set Mr. Griffin for a docket call hearing on Mr. Schmidt, so if you have your August calendar, are you available on Thursday, August 1st?
Yes, Your Honor.
All right, court sets Mr. Griffin for docket call August 1st. That'll be at 9 a.m. And so, Mr. Griffin, because they did not take your fingerprints when you were arrested, they need to do that. And so I've given your attorney an order. I want you to take that order, go out to the jail, to the Justice Center on Highway 64 after court. Bring your ID with you along with that order and go in there and just let them know you need to get fingerprinted. When they see the order, they're going to know. They're going to take you back, they're going to put your fingerprints onto the glass, scan it, and that's going to be it. You're not going to have to dress out or get put in a cell or anything of that nature. It's just a procedural issue that we have to satisfy for the state of Texas. Okay. All right. Once you sign your notice of resetting and you get that order for your TRN, you're free to go.
Yeah, maybe, excuse Your Honor.
Yes.
Here's that order. Let's step back. I'm gonna ask Ms. Corey when she wants.
Okay. Mr. White, are you ready?
Yes, sir. I am.
Larry Wayne Marshall, CR 23-222. Marshall set for docket call. Go ahead, Mr. White.
Yes, sir. We're set for docket call this morning. At this time, we're now ready We understand, and I explained this form, this rejected, or by pronouncing ready, rejected, state's offer. And then at that point, it's solely in your discretion whether you don't move. So, everybody understands that. Ready to go.
And just so I can have it on the record, what offer was extended and rejected?
Your Honor, I don't know exactly what terms. Can't remember exactly what terms they were,
Your Honor, stated offered, if I could have just one moment. A deferred finding on a third degree lesser.
So that was deadly conduct lesser.
Yes, Your Honor.
All right, court has noted that for the record. All right, court will set Mr. Marshall then for jury trial. We'll begin that, Mr. Marshall, on Monday, June 3rd. You're to appear on that day downstairs. My court staff will be with you. They'll give you a reset notice. The pretrial release officer is likely to be there as well. Check in, you'll get your new date. You'll be reset. You'll continue to do that until your case is moved to trial. Mr. White's not going to be required to be here on that day because your case will not be in the top 10 on that day.
Downstairs where.
Yeah, just when you come into the courthouse on the second floor. Yeah, you just won't report here because we'll be picking a jury for another case. But when you come in downstairs, my staff will be there and they'll direct you.
Okay, thank you.
Is that all you have, Mr. White?
Yes, sir.
Man, you ready?
Yes, sir.
Are you ready on?
Judge, if we want to start with Mr. Blackman.
Trevor Blackman, CR 23-200. All right, Mr. Blackman is set for a docket call today.
Yes, Judge. We've reached agreement on his case for a plea. We request to be set on a plea docket for a month out.
Your Thursdays, correct?
Yes, Judge.
You want to do Thursday, June 13th?
Judge, let me check just one moment. Judge, that'll work.
All right, court sets Trevor Blackman for plea before the court on Thursday, June 13th at 9 a.m.
And Judge, I was provided with a restitution number on this case yesterday. My client and I haven't had an opportunity to discuss that and to review the evidence surrounding or supporting that plea. I would ask if we do need a restitution hearing, would we be able to have that on that day, or do we need to have it set for another day?
If we need to have a hearing, it'll need to be on an evidentiary day, which would be that following 20th.
I don't believe we're going to at this point, but if it becomes necessary, we need to contact the court coordinator.
Yes, just contact the court coordinator in the state and we can reset it for the following Thursday, the 20th.
Thank you, Judge. Mr. Blackman, be excused.
Yes, free to go.
Thank you, Judge. Judge, next ready on Mr. Chavez Torres.
All right, this is cause number CR 24-46, Mr. Randy Ronaldo Chavez Torres, set for arraignment, has been verified in custody in the Hunt County Jail. I'm not sure if he's being held on our warrant or another warrant.
Judge, I believe he's being held on a warrant for burglary of a building out of Hunt County.
Okay. All right, court will reset Mr. Chavez Torres for arraignment. Let's just set on that June 13th. For arraignment and custody status.
And Judge, you want that at 9 AM or 1:30?
Let's keep it at 9 AM.
Yes, sir.
And then if we need a bench warrant or something, and that's requested, we can always move it. to 1:30.
There you go.
I called Joseph Ryan Hazel. Is Joseph Ryan Hazel here? You know anything about Mr. Hazel?
Judge, my last conversation with Mr. Halo, he is intending to show up today for a reset for a plea. And I believe my conversations at the beginning of this week. So if I may just have a moment to step out, see if I can't locate Mr. Hazel.
Okay.
Next, I'm ready on Mr. Overstreet.
Jimmy Lee Overstreet. All right, Mr. Overstreet set for docket call.
Judge, yes, he is set for docket call. And this morning, Mr. Overstreet informed me that he would like to take the plea offer that's been offered by the state. I have not had an opportunity to discuss some of the ramifications of that plea offer, and so I'd ask we reset it for a plea, so that I have a little additional time for me to discuss chapter 62 and other things that would be a part of that plea.
We're gonna do that June 13th.
Judge, I think that should work.
All right, court sets Mr. Overstreet for plea on June 13th. At 9 AM.
Thank you, Judge.
I'm assuming that's a 9 AM plea rather than a 1:30 plea.
Judge, actually, no, that would be a 1:30 plea.
1:30? All right, court will set Mr. Overstreet for June 13th at 1:30.
I'll instruct him to report to the jail. May Mr. Overstreet be excused?
Yes, free to go.
Thank you. Finally, Judge, ready on Mr. Floyd. Dennis Floyd.
Dennis Floyd. All right, this is Mr. Dennis Floyd. I believe he's set today for compliance with the court's pretrial release conditions.
Yes, sir.
Anything from the state?
Your Honor, the case we have not reviewed as far as intake goes. We were made aware of some issues with pretrial release compliance. Beyond that, Your Honor, state has no further information.
All right. All right, so I believe Mr. Manning and Mr. Hartwell, I believe that Mr. West had indicated to the court and to the state, to the defense as well, that Mr. Floyd was placed on pretrial supervision on November 12, 2023. And since then has failed to report for December 23, January of 24, February 24, and March of 24.
Judge, if I may.
Go ahead.
I confirm with Mr. West that my client had not reported as he had been instructed initially. I'm not sure if there's some confusion. My client's part, as he was released on a PR bond, I don't know if maybe he didn't understand the conditions against him, but he has been paying his monthly fees. I believe he is at this point in time about $120 in arrears, but he is able to pay that today. He has been making his monthly payments And he thought that satisfied his reporting obligation. I explained, and Mr. West explained to him today that that is not the case. That he is required to report monthly and he is ready and able to do that. We'd ask that, because of the length of time that this case has been pending, that he be able to remain on his personal bond. He is here today, Judge. Obviously, he received notice, and appeared today. Even though I wasn't able to get a hold of him, he was here present. And so we'd ask that he remain on pretrial release conditions with compliance to be forthcoming.
And Your Honor, outside developments with the case, involving possible, federal agencies or other state agencies. So we'll be in communication with Mr. Manning and with the court, if any of that would change our stance on pretrial release. Or I suppose whether we were going to proceed with the case at all.
All right, so Mr. Cheatham, you understand now that, I'm sorry, Mr. Floyd, you understand that you are required to report as directed by your pretrial release officer? It's in those conditions. If you knew to pay, then you knew to report because it tells you in there. You
And
understand?
Judge, we spoke about that when Mr. Floyd first got out of jail. He was unable to report due to some medical stuff going on, and so like I said, there may have been some miscommunication or misunderstanding on Mr. Floyd's part as to whether he needed to continue reporting.
Mr. West, do you have a position on this? All right, I want you to go ahead and drug test Mr. Floyd today. That's going to determine whether he stays with me or he goes home. All right, so go ahead and go with Mr. West, take a drug test. If you pass that, then I will leave you on your bail, your pretrial release. If you don't pass that, then we'll have a different conversation. So you're not free to leave until I tell you you're free to leave.
And Your Honor.
Sorry, I just wanted to see if you the reason for.
You need Ms. Curry out here?
No, sorry.
All right, this is cause number CR 23-224, Christian Munus.
Present, Your Honor.
All right, we're set for docket call. Go ahead, Mr. Schmidt.
We are, Your Honor. I met with Ms. Curry at her office Monday to go over some various things in the case, and the DA's office has had the subpoena, a portion of the same records. They have not received those back yet, but that will be the final piece of discovery that's outstanding. She indicated they should receive that relatively soon, so if we could potentially have a final docket call in June, that will be sufficient time if that's acceptable.
The last setting I have in June would be June 18th. Enough time.
I think it will be, Judge, and in fact, I'll be here. I'm available the 13th or the 18th, so,
We can do the 13th. I was just trying to give you more time, but
well, it's, she said they should have them pretty quick, so either date is fine with me. Maybe the 18th, just, I don't know, abundance of caution.
we can set it the 13th since you're already gonna be here. If we don't.
Well, I'm not, what I meant to say is I can be here either day, so I don't have anything set.
Your preference, 13th or 18th, your call.
Let's give them some time. This 18th will be fine.
Okay. All right, court sets Mr. Munoz then for docket call and status of sane records on Thursday, June 13th. That'll be at 9 a.m.
Oh, the 13th,
I'm sorry, 18th.
Tuesday.
18th. Tuesday, June 18th.
Yes, sir.
Docket call and status.
Very much, Judge. I've given him a copy of that. May he be excused.
What's that?
May he be excused.
Yes, free to go.
Thank you. And that's all I have. May I be excused this morning.
Yes, free to go. Good to see you.
You too, Judge.
pretrial release compliance. The court, having heard the concerns of the pretrial release officer regarding Mr. Floyd's non-reporting, the court indicated that it was going to conduct a urinalysis test of Mr. Floyd, and the court has done so. Is Mr. West available?
Judge, I thought I just.
Go ahead and have a seat. I'm going to recall you in just a moment. Mr. West may be conducting another urinalysis of another individual, so it may be a few moments. So go ahead and have a seat.
And Judge, I'm Mr. Hazel. I have reached out to him via email. I think his phone number must be at my office. I would ask that the NICI be held off until later today. As I said, I had a conversation with him. His full intention was to take a plea today. It was gonna be for time, so I don't know if possibly he thought he was supposed to be here at 1:30, or if, I told him we're gonna be resetting the plea, because we did get the deadline for the states to get the paperwork ready. We didn't get that in time. And so, possibly there's some miscommunication on between he and I, as to when he was supposed to be here. If I could just have some time to sort that out. I anticipate he will be, as I said, taking a plea for time, on our next week.
All right, court will, I'm going to have his name called. If he does not appear before noon, court's going to take a judgment NICI under advisement until 4 o'clock today.
Thank you, Judge.
All right, Mr. Floyd, step back up. Mr. West, if you'll come in. All right, we're back on the record in the matter of pretrial release compliance with Mr. Dennis Floyd. All right, Mr. West, I'm going to ask you to raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, and Mr. West, the court requested that you conduct a urinalysis test of Mr. Dennis Floyd, who is court ordered to be drug tested while on conditions of pretrial release. Did you conduct that urinalysis today?
Yes, I did.
And what were the results of that test?
Positive for methamphetamine.
Positive for methamphetamine. Did you have any discussions with Mr. Floyd about the results?
He denied use of methamphetamine, so therefore I said you'd send it to the lab to confirm.
And did you ask Mr. Floyd if there was any reason that he would be testing positive for methamphetamine, such as being on medications or any other thing that could cause positive result?
I did while we were in the restroom. I asked him if he was using. He denied it, and then asked him if he was on any medication. Stated he wasn't, and then when I came back outside in the hallway, he stated that maybe it was Viagra. Is one.
Mr. Manning, any questions of Mr. West?
Mr. West, will this sample be sent off to be tested and confirmed by a laboratory?
Yes.
No further questions for this witness.
Say any questions? of Mr.
No
West?
questions, Your Honor. Thank you.
All right, court's going to find that Mr.
Before we may, if I had a brief argument.
No, that's okay. Court's gonna find that Mr. Floyd has violated the conditions of his pretrial release by testing positive for methamphetamine while on conditions of pretrial release. Court's gonna find his bail is insufficient at this time. The court's taking Mr. Floyd into custody, and I'm gonna double bail.
Judge, if I'm,
You wanna approach Mr. Manning?
Can I?
Your excuse, yes. Will you approach Mr. Manning, Stiggs? All right, Mr. Manning, I'm gonna let you make your argument on the record. Go ahead.
Judge, under 3201, we would request that this case be dismissed as it should be noted for the court that Mr. Floyd is yet unindicted. His date of arrest was July 24th of 2023, and we believe that under 3201, this case should be dismissed for untimely prosecution at this point in time.
And what's your basis for the 3201 argument? Why do you think that the time has expired and the court no longer has jurisdiction over him?
Judge, it's been over 6 months. In fact, it's closer to a year since he's been arrested on those charges, and an indictment has not been filed.
Any response from the state?
Your Honor, as to the facts, no, state would just rest on the court's interpretation of the law.
All right, the court in reviewing Article 3201, which has been cited by the defense in this case, the court finds that the law requires that the case be dismissed and bail discharged, including the conditions of pretrial release, if indictment or information be not presented against the defendant on or before the last day of the next term of the court, which is held after the defendant's commitment or admission to bail, or on or before the 180th day after the date of commitment or admission to bail, whichever is later. Court finds that Mr. Floyd was arrested in July of 2023. Therefore, the application of 3201 court's interpretation would not become effective until the last day of the term of court for this term, which is January through June of 2024. Hence, the whichever date is the later. So the court finds that Article 3201 is inapplicable to the defense's argument at this time. As such, the court finds that despite Mr. Floyd not being formally charged by the state, that he is in noncompliance with his conditions of pretrial release. The information before the court is that Mr. Floyd, although in compliance with certain portions of his pretrial release, has failed to appear for multiple months. The court had the indication today, the feeling that I was going to allow Mr. Floyd to remain on conditions of pretrial release subject to no passing a drug test. Court finds that the drug test being administered today has resulted in a positive finding of methamphetamine. The court's directing the Van Zandt County Community Supervision and Corrections Department to send that result off for further scientific testing. In the meantime, the court finds that Mr. Floyd has failed to comply with the court's previous order and has failed to report. And the court today finds that the evidence supports the reason for his failure to report is his use of a controlled substance. So the court thereby finds his bail to be his $50,000 personal bond to be insufficient. And the court is setting new bail at $100,000 cash or surety. And Mr. Floyd is ordered to be taken into custody at this time.
Your Honor, may I have a moment to speak to my client?
After he's taken into custody.
And Judge, I would ask, just finally, if the state does not present an indictment prior to June 30th, that the court will permit us to re-raise this argument.
Yes, sir. Yes, sir. If you'll file your motion, or the motion has been made, but the court's denied the motion at this time. If you'll raise the motion again by a written filing, the court will reconsider it should Mr. Floyd not be indicted timely under 3201.
Thank you, Judge.
Thank you, Judge.
Just asking. It's not this evening. Mr. White, are you ready?
Yes, Your Honor, but I think we need to approach on.
Please.
Forward.
All right, we are on the record. Ms. Anderson, if you'll come forward, please. This is cause numbers CR 23-197, 198, and 199, State of Texas versus Cat Wallace, Chantel Anderson. We're set for a plea today. Ms. Anderson, if you'll raise your right hand, I will place you on the road. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. All right, Ms. Anderson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White and the legal work he's done for you? You feel like you've had enough time to talk with him about all of your cases to the point that you have had all your legal questions answered and you understand everything that you've read and signed in your plea agreement? Do you have any questions before we go further? Mr. White, do you believe Ms. Anderson to be competent?
I believe she's competent and is able to make the decision she's made today.
And do you believe that after understanding her rights, that she's entering into this agreement intentionally, knowingly, and voluntarily?
I believe so.
All right, Ms. Anderson, you are charged by indictment with a second-degree felony offense of possession of marijuana greater than 50 pounds, less than 2,000 pounds. A second-degree felony does carry a range of punishment. If you were to be convicted and sentenced, the sentence must be not less than 2 years in prison or more than 20 years in prison, and carries an optional fine not to exceed $10,000. I see that the plea agreement in your case is that the state's recommending that after reviewing the evidence, the court defer a finding of guilt in this matter. That means that the court review the evidence and not convict you, but place you on 8 years of community supervision, ordering you to pay a $2,000 fine, $290 in court costs, and $35 in reimbursement fees. In addition, it appears that the state would be asking the court to take into consideration in this plea agreement two indicted cases, CR 23-198, which is unlawful use of a vehicle, and also CR 23-199, unlawful carrying of a weapon, that those cases would be dismissed, considering your sentencing in the marijuana case. Is that your understanding of the plea agreement? And that's what you want the court to approve? All right, Ms. Anderson, how do you plead to possession of marijuana, 50 pounds to 2,000 pounds? Are you pleading guilty to that crime because you are guilty of committing that crime? And has anyone threatened, forced, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence supporting the plea?
No objection.
The stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
No, no.
All right, the court's going to review the stipulation of evidence. All right, court has reviewed the evidence. The court finds enough evidence to convict Ms. Anderson. Court will follow the recommendation of the state today in the plea agreement with the defendant. The court hereby defers a finding of guilt on the second-degree felony offense of possession of marijuana greater than 50 pounds, less than 2,000 pounds. The court, in deferring a finding of guilt, places Ms. Anderson on 8 years of community supervision, orders her to pay a $2,000 fine, $290 in court costs, and $35 reimbursement fees. Court also takes into consideration under section 1245, unlawful use of vehicle and unlawful carrying of a weapon. Mr. White, I failed to ask you this earlier, but do you believe that your client understands the advantages and disadvantages of a deferred adjudication plea?
We did go over that, Your Honor. We understand that once we complete this probation, that the charges will not be resulting in a felony conviction. Also understand that there's a very big hammer that in the event that something does go wrong, we are subject to 20 years and $10,000 fine.
Thank you, Mr. White. And you agree with that, Ms. Anderson, that's your understanding as well? Any questions about that? All right, Ms. Anderson and Mr. White, if you'll both come forward, Mr. White, I'm gonna get your signature. Ms. Anderson, I'm gonna get your fingerprint. Ms. Anderson, if you'll step over there with Jeffrey Martinez. This one. That all you have, Mr. White?
You know, I would have to play on that shoes.
Okay. Are you ready on that one? Yeah, come on. Mr. Shields, if you'll come forward. This is cause number CR 22-363, State of Texas versus David James Shields. Mr. Shields, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. You lower your hand. All right, Mr. Shields, your name is David James Shields, correct? Yes. Mr. Shields, are you a United States citizen who reads, writes, and speaks English? Yes, sir. And in this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White as your attorney? Yes, sir. You feel like you've had enough time to discuss with him your case and that you've had all of your legal questions answered? You understand everything about your plea agreement? Is there anything that you do not understand or questions that you have? No, sir. Mr. White, do you believe Mr. Shields to be competent?
Yes, Your Honor.
And you've explained to him his rights as they pertain to this case?
I have, Your Honor.
And do you believe that he is entering into this plea intentionally, knowingly, and voluntarily?
I do.
Mr. Shields, you are charged by indictment with a third-degree felony offense of accident involving serious bodily injury. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and also a fine, if imposed, not to exceed $10,000. I see that the plea agreement in your case, the state's recommending that the court review the evidence, defer a finding of guilt, and place you on 6 years of community supervision, a $2,000 fine. In addition, you would have court costs and reimbursement fees, and the state is willing to dismiss their driving while license invalid. Mr. Shields, is that your understanding of the plea agreement? Yes, sir. That's what you're asking the court to approve? All right, and Mr. Wright, did you and your client go over the advantages and disadvantages of a deferred adjudication plea?
Once again, Your Honor, my client understands that if he completes his probation, this will not result in a felony conviction. If something goes bad, he's looking at 10 years and a $10,000 fine possible.
Thank you, Mr. Wright. And you agree, Mr. Shields?
Yes, sir.
All right, then, Mr. Shields, how do you plead to accident involving serious bodily injury?
Guilty.
Are you pleading guilty because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty? Court does accept the defendant's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, thank you.
And while we're on this issue, is there victim compliance, victim notification? Is the victim supportive of this plea?
Just a moment, Your Honor.
Yes, Your Honor, the victim impact statement was provided. It was not returned. State is in compliance.
And so you have had no communication with the victim?
No successful attempts, Your Honor.
Anything further from the defense, Mr. White?
Nothing, Your Honor.
All right, court's going to review the evidence. All right, court reviewing the evidence finds sufficient evidence to convict Mr. Shields of this offense. However, the court does follow the recommendation of the state of Texas in the plea agreement with the defendant. Court hereby defers a finding of guilt on accident involving serious bodily injury. Court places Mr. Shields on 6 years of community supervision, orders a $2,000 fine, $290 in court costs, $70 in reimbursement fees. And the court dismisses under section 1245, unfiled driving while license invalid, cause DA 2020-0815. All right, Mr. Shields, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, you'll meet with the probation officers and they'll give you more information. Go on forward.
I believe that does take care of all my business.
Thank you, Mr. White. You may be excused.
Thank you.
Mr. Moore, you ready?
I am, Your Honor, Mr. Curry, I don't expect.
Mr. Curry, are you ready with Mr. Moore's client? Mr. Moore's client, Wayne Stafford. Mr. Stafford, if you'll come forward. This is cause number CR 23153, the state of Texas versus Wayne Stafford. Is Mr. Stafford entering a plea today?
Yes, sir, he is.
Do we have paperwork?
Oh, yes, Judge, I'm sorry. And Judge, this guy's wife was coming from out of state. She's running a little late, but she's coming up the courthouse steps right now.
I understand she wants to allocate.
Yes.
All right, Mr. Stafford, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
And lower your hand. Your name is Wayne Stafford, is that correct?
Yes, sir.
Mr. Stafford, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. David Moore. Are you pleased with Mr. Moore and his representation?
Yes, sir.
Feel like you've had enough time to discuss your case with him, that you've had all your legal questions answered, and that you understand everything that you've read and signed today as part of your plea agreement?
Yes, sir.
And do you have any questions before we go forward?
No.
Mr. Moore, do you believe your client to be competent? And if so, have you explained to him his rights as they pertain to this case?
Yes, sir, he is confident and I believe he fully understands his rights.
And do you believe he is entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, yes, sir.
All right, Mr. Stafford, you are charged by indictment with a state jail felony offense of criminal negligent homicide that does carry a range of punishment if convicted and sentenced to no less than 6 months in a state jail and no more than 2 years in a state jail, and a possible fine not to exceed $10,000. I see the plea agreement and recommendation from the state of Texas is that upon reviewing the evidence that the court defer a finding of guilt, that means not convict you. but place you on 4 years of community supervision with a $2,000 fine plus court costs and reimbursement fees. Mr. Stafford, is that your understanding of the plea agreement?
Yes, sir.
Is that your understanding as well, Mr. Moore? It's okay. I just want to make sure that there are no changes.
That's correct.
Okay. All right, understanding the range of punishment, understanding the plea agreement, Mr. Stafford, I'm gonna ask you at this time, how do you plead to criminal negligent homicide?
Guilty, sir.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty here today?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. Moore, any objection to the stipulation of evidence?
No, Your Honor.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
We will have victim allocution, Your Honor, but nothing on the plea.
All right. And is the victim's family supportive of this outcome?
Yes, Your Honor. They are distraught, Judge, and they understand there's no plea that will make them whole. But, we've met with them many times throughout the course.
Thank you, Ms. Green. Anything further, Mr. Moore, from your client? All right, court's going to review the evidence. All right, the court, having reviewed the evidence, finds sufficient evidence to convict the defendant. However, the court will follow the recommendation of the state and the plea agreement with the defendant. The court hereby defers a finding of guilt on criminal negligent homicide. The court orders Mr. Stafford to 4 years of community supervision, orders him to pay a $2,000 fine, $290 in court costs, and $70 in reimbursement fees. Mr. Moore, did you and your client discuss the advantages and disadvantages of a deferred adjudication plea?
Yeah, yes, sir, we did it length.
All right, Mr. Stafford. I hereby remand you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, I'm gonna have you have a seat at council table here so that we can receive the allocution from the victim's family. And after that, then you'll meet with the probation department for more information. Court's going to direct a court reporter that this is victim allocution and that's not to be reported on the record.
When everything happened, we were notified almost a day later because it happened early in the morning. I actually had to look up to see, how this process would go when you're given this type of victim statement. and many emotions came about. I had to write my brother's obituary. When you think of obituary, there's a start date, there's a in-between date, it was in between, there's a start dash and then the end date. This gentleman's actions caused the end date. My niece and nephew lost a father. He won't be able to see his daughter get married, have a child. His son, who carries his name. Carries my father's name. He won't get to see William Robertson the fourth, because of, again, this gentleman's actions. I don't say he did it intentionally. I never think a human could do that, but I can say, still, your actions caused this. My brother was a protector. He was a man about family. He stood firm on, if he did something, he would stand firm and say, I did it. I look at this case and I switch roles and say, what if my brother hit this gentleman? My brother would often tell me, he would say, Reg, I did this. I'm gonna go tell them it was my mistake. I did this. I don't want that family to go through anything. I want to send them my sincere apology. Won't do any good, but I'm not gonna say this or that happened. I made the mistake. My actions caused a death. I didn't see that here. Again, my brother would have done that. Still, all the emotions in the world going through all this, I can look and see that when my father passed and I was 9 years old, and I saw my grandfather, I saw the look on his face. I looked at him as we sat on the first row in a church, saw his face. I saw how he broke down. I'd never seen that man that low until I saw my mother's eyes. I saw that same pain, that same hurt, and it dawned on me, she's not to bury him. He was not to bury his son, my grandfather. They are to bury him. Again, this gentleman's actions caused that. I sat in the hallway this morning. This gentleman walked in front of me. He knew who I was. He knew who I was. Him as attorney, discussed the case, discussed the probation in front of me. There's a thing of class, decorum. They could have moved to the side doing that. I sat there and heard that. Do your probation, pay your fees, on and on. That's what we've dealt with this case. No empathy, no sympathy from anyone but Melissa, the trooper on site. I forgot his name. He generally just pretty much pastured me when I called him in tears to see what happened. As he told me what took place, he said, Mr. Robertson, your brother did everything right. He moved over to the side where the legal right he had. He was not obstructing the path of anything. He did everything correctly. His car broke down. He was using his phone as a flashlight as the truck hit him. That gave me peace. And he said, Mr. Robertson, he didn't know what he did. So deal with that. Every day. Think about him every day. I won't forgive this gentleman as long as I live. Again, I don't think he did it intentionally, but his actions caused my brother's death. I have to live with a $2,000 fine, court case, community service. But I'm man enough to live with it. I can deal with it because I know this is the law. I can't change anything, but it does not bring him back. No amount of money will, no nothing. But I can stand firm again and say, if my brother did this, he would stand firm and said, I did it. I don't want the family to go through any pain, any anguish, nothing I can say to bring them back, because my brother would be in a death himself if he did this. But again, I can sit here and smile and say, when this gentleman took my brother's life, my brother was reunited with his father, William Robinson. So I'll take that for the rest of my life. And as I sit here and I can look at my grandson who will be here in a month or so, I can look at them with my eyes and say, I'm looking at you through my father's eyes, through my brother's eyes, because I'm holding my grandson something they did not get a chance to do. And again, Mr. Stafford, I can look at you and say, I don't believe you did it intentionally. But just as we walked in the hall and you didn't make any eye contact with me, and you and your attorney discussed the probation, so I wish on you. I just hope and pray it eats at you for the rest of your life. Thank you.
All right, Mr. Stafford, you can report to probation officers. Oh, I'm sorry. There's one more. I'm sorry. I apologize.
It ain't a matter of how it's said or it caused a major burden to me. It really did. It put a damper on my family. It really did. And we have two children. One is she's in college. Her first year, she's a freshman. My son, he was a senior, so he was looking forward to graduation and everything. And his dad it was just a joyful time for him. I mean, he really like, I'm gonna do this for you, Dad. We gonna do this. And they talked about it every day. And once this happened, it was hard for my son. It was really hard. I couldn't get him. He couldn't focus. It got so bad to where before he graduated, the principals, everybody had to sit him in his office because it just did something. He couldn't sleep. He couldn't do anything. It was hard on me and my kids. I don't think you did it intentionally, but you really, really, really put a burden on us. I often said, I'm like, I know how it is with the law, and they'll tell you don't contact, no contact with the family, no, don't do anything. But to me, it would have said a lot about you. Even, I don't care what it is, because my husband, if the attorney couldn't tell him, even if he had to go through attorney, he would have sent his condolences. I didn't know anything about what was going on with you. The only thing that I heard is that you want to come up with a way to just resolve it. But the first step of resolving is acknowledging what happened and what was wrong. It was a big, big burden on my family. Like I said, I don't think it's intentional. I really still don't know what happened. I really don't know what caused it. But I just want to let you know, we come along with the family. You know, my son, he got 3 uncles that act just like his father, you know what I mean? So that right there, you know, it helped out. They helped me, but I don't think I've been with my husband. We was married for 19 years, almost 20 years. And so it's just that I'm 42 and a widow. I'm a widow. This it really hurting my family, you know, but I know it was God's will, you know, on what happened. And I can say that, you know, that I forgive, but I just cannot forget. And I believe, you know what I'm saying, it could have made me feel a little better had you reached out and gave your condolences. It would have meant a lot to me. It would have been a lot to me, but I know how the law is, you know, most attorneys be like, no, don't do that. But I hate that. I hate that law because especially if this wasn't intentionally, my husband would have if it would have got him in trouble, he would have definitely gave his condolences. So here I am, widowed, 2 children. By the grace of God, they pulling through. My daughter, she's succeeding in college. She's on the dean's list. Her daddy will be very proud. My son, he going to Kilgore. He going to be a firefighter. That's his dream. So we just trying to make it, you know, in God's will. Like I say, I forgive you. I won't forget, but I forgive you.
Any more allocutions, Kurt?
No, Your Honor, thank you.
All right, Mr. Stafford, I want you to report to the probation if you will. You may, thank you, Mr. Moore. Ms. Curry, roll around with conceal. Court is calling cause number CR 23-166, State of Texas versus Miguel Angel Castro Guevara. It's my understanding that the state and the defense are asking for one final setting on Tuesday, May 28th. Is that correct?
That's correct, Judge. In light of the fact we don't have an interpreter today and there's still some things going on, the 28th would. This case will either be resolved or not by the 28th.
Mr. Valderrama?
And that's my understanding, Your Honor, that the 20th is be the, our final, reset as to whether we're gonna get this resolved, or not.
Okay, I do want the record to reflect that Mr. Castro Guevara does need the assistance of a licensed court interpreter. We had one arranged for Mr. Castro Guevara. However, Mr. Valderrama was not here at 9:50, and so we waited till 11 o'clock, and the court reporter had to be released. So today's hearing is not with the assistance of a court interpreter. And because today's, there's nothing substantive occurring today, and this is a resetting, I'm relying on Mr. Valderrama as an officer of the court to convey that to his client, that we're going to set this for one final hearing at the request of both the state and the defense for less than 2 weeks, May 28th at 10 a.m. May 28th at 10 a.m. And that's going to be a final docket call. The court will arrange to have an interpreter available on the 28th at 10 a.m. Mr. Cheatham, come on up. You come up here to the middle, it's fine. This is a sanctions court hearing, Mr. Kalen Cheatham. All right, Mr. Cheatham. All right, this is a sanctions court hearing today. This is your first time at sanctions court. Do you know what the purpose of sanctions court is? Fees. Well, those are things that we address, but do you know what the purpose and the spirit of sanctions court is?
To tell you what I do better or what I can do.
In essence, let me state it this way for you. You're currently on community supervision deferred. You took a plea. You took a plea on looks like April 25th of last year for evading arrest or detention with a vehicle, a third-degree felony. The court placed you on deferred community supervision because that's the plea agreement that you worked out with the state. Court approved it over a year ago. And as part of your community supervision, you were ordered to do several things: make payments towards your probation fees, make payments towards your court fees, work your community service, drug tests, all those things. Purpose of sanctions court is for the probation department to be able to identify people who are either not taking their probation order seriously, or there's some intervening cause that's preventing someone from doing what they're court ordered to do. And the purpose of sanctions court is to try to intervene in the probation of someone to prevent them from being revoked and either going to jail or prison, becoming a convicted felon. All right. So you're looking at the possible sentence that you're looking at for a third-degree felony is up to a maximum 10 years in prison. Okay. And so the notes that I'm getting from my probation officers is that, you're not making your probation fees, you're not paying your court collection fees, and you're not working community service. So over a year has gone by and you've not worked a single hour of community service. You're delinquent 120 hours. The probation department could file a motion to revoke today. Ask me to put you in jail, let you get an attorney, allow the state to come in here and argue whether or not you should be revoked and sent to prison. So the purpose of sanctions court is to try to determine if you're one of those people that with a lower court intervention, you can start doing what you said that you were going to do and prevent you from getting a motion to revoke and facing a prison sentence. Do you want to go to prison? Okay, how old are you?
24.
24, you're a young man.
25.
25?
Yeah, I just had
Hey, I lie about my age too. Are you married? Do you have kids?
Yeah, I just had my first one.
How long ago?
2 months ago.
2 months ago. Boy or girl? Girl, what's her name?
Mitch.
Okay. Do you think that she needs her dad in her life?
I say, yes, sir.
I know you're nervous. It's okay. But listen, you're not going to jail today, so just relax. You're not going to jail. I've already drug tested you. You're negative. That's a good sign. I'm trying to get your attention. And so I want to know, does your daughter need her dad in her life? Okay. Is your daughter, you said she's your first child. Do you want to be in her life? She needs you in her life. Do you want to support her? Do you want to be able to go to work, make money, and buy the things that she needs? Do you know the only way that you can be in her life, and she can be in your life, is to get this court order probation out of the way? So in order for you and your daughter to be able to do those things, this probation has to be a priority. A priority. Is your daughter a priority? Okay. They're gonna have to be even priorities, because if you make your daughter a priority over probation, then probation is gonna take you away from your daughter. Okay? So they're gonna have to be even priorities. So that means you have to make your probation fees. You gotta pay them. Okay? You've got to pay your court collection fees. And you're gonna have to find time to do community service. I don't know if you're working. You're working?
Yes, sir.
Okay, what do you do?
I work at the airport and got my CDL.
All right, so you work at the airport, and you got a CDL. So there's a lot of things that could go really good for you. That's a good job, and having a CDL makes you more employable because you have a skill that you can earn good money. It'd be a shame to lose those because you're sitting in jail waiting on a motion to revoke here. How long do you think your job would wait on you? Huh? How hard was it to get that job?
Yeah,
I
especially
know.
with Drake.
It's very difficult to get a job at the airport. I know this. So how sad would it be because you're not doing your community service, that you lose that job, you lose your liberty, lose time with your daughter? Can you think of anything worse? I can't think of anything worse for me than losing my job, losing my liberty, or losing my kids. I can't think of anything worse. You could kill me. That would be better than living in the agony of those three things.
It's not a place I need to be in.
Yeah, it's not a place. You're no good to nobody. And we don't want you there. That's why you're in sanctions court today. And that's why you're not sitting in the Van Zandt County Jail wearing an orange jumpsuit, wearing chains and being brought over here. It's because the probation department told me to get your attention. Okay, now we're not playing in three strikes. You don't get to come in here several times. This is your opportunity to understand how serious this is. Okay, this is not a misdemeanor probation to where, hey, revoke me, I'm gonna go sit out a weekend and be done. We're talking about felony conviction that follows you for the rest of your life. Affects your ability to get a job, to get a loan, finance, trust for the rest of your life. And and once you get a felony conviction, the only way to get that off is by a governor pardoning you, giving you a pardon. Okay, they don't hand those out. All right, so this is something, once you get it, you're stuck with the rest of your life, and it has such a negative effect on you. Okay, so there's so many things that you should be stressed out about. All of these things we talked about. losing your daughter, losing your job, losing your liberty, getting a felony conviction, going to prison. These things should be the first thing that pops up in your mind when you wake up in the morning. Your probation officer, you should be on a first name basis with you. They should be able to, when you come in, they should be, hey, Caitlin, how you doing? Good to see you. Everything looks great. Keep it up. Good job. Maybe we can get you out of here in half your term. If you'll jump on this and get these things done, we'll get you out of here. You got 3 years. You could be done in a year and a half if you would have started early. I mean, we could have been having letting a hearing where I could let you off with a year and a half if you would have already done these things. Right now, we're kind of pushing up towards the other end of it, that we may have to extend you in order to get you done. So when you pop up in the morning, you should be thinking, how am I going to take care of my business today so that I don't have to go see that judge down in Canton? All right. So I'm going to do my job and give you this opportunity. All right. And I'm going to have you come back to court every month for a while until I know that 1, I got your attention, 2, you're serious about your probation, and 3, you can handle it. Once those 3 things happen, I'll let you go back to reporting. Where do you report? You report in Dallas. Right. I'll let you go back up there. I mean, you're still going to be reporting there, but I'm going to drag you down here until they quit sending me messages. When they tell me, hey, we're good with Caleb. He is straightened up. He understands. He's not going to screw up anymore. He's taking care of his business. When they tell me all of that, then I'll let you just go back to straight probation. And you handle your business and you won't have to see me anymore. The next time I see your name, it could be, I think, didn't I release some people today? I've already released some people today on probation. So the next time I see your name after sanctions court should be on a motion to dismiss the case. All right. So is there any reason, this is your opportunity to talk, okay? Is there any reason that you're not paying your probation, you're not paying your court fees, you're not doing the service?
The reason for the court fees and probation fees was I just kind of started trucking. And then like the company I was with, they stopped having the freight. So that's what made me have to go back to the airport and get that job. So I just got that. So I will be making a payment on the 24th because that's what we paid every 2 weeks. But I'm starting Amazon too for their truck driver. So I'm waiting on their background to come back and they cleared. And she said it should be done by like Friday. So I'm switching up and leaving the airport to go make extra. So
they can get more money driving Amazon.
So the community service, I had asked my probation officer in Dallas, and she was like the Salvation Army or something. But I went up there, they said they didn't have anything for me to do. So I'm trying to, I know y'all have like the first Monday and stuff down here and everything. So I'll probably just come back down here and do that.
If you want to come down here and do your community service, contact the office, they'll set you up. If you're dealing with your probation office in Dallas, I'm not sure. They probably have a list of places. I don't know. If you'd rather come down here and do your community service here on the weekend, do first Monday, 40 or 50 hours and knock it all out, we're fine with that. They can do probation hours down here. So if you want to do that, we've got plenty of places down here. When you show up, they will have stuff for you to do. Yeah. Otherwise, you got to get with your Dallas probation officer if you want to do it up there and find the list of approved places and get that coordinated. Yeah. All right. So this is what we're going to do. Caitlin, I'm going to bring you back. I'm going to bring you back on June 18th. Okay. At 9 o'clock. And this is what I want you to do, okay? I want you to pay $120 to probation. So that's like 2 months. Well, I'm gonna try to get you caught up. Okay. Your court order payment is 60, I think. Okay, so I need you to pay 2 months so we can get you caught up. Okay, we're gonna do this for a while until we get you back to where you're caught up. I need you to pay $100 to your court collection, so that's $220 total. Okay, and I need you to do 15 hours of community service. We'll give you 30 days to get all that done. Okay, you're gonna come back on the 18th. You need to have all of that done and turned in by Friday the 14th. Okay, Friday the 14th.
I put it in my notes, I never get that over there.
Yeah, and she's gonna write it all down for you right there. We're gonna have you sign it, and then we'll put the date and the time on there. And then, just get all that turned in to your, probation officer the Friday before. And then they'll send it down here and we'll get it all, in my report, and then I'll see you on the 18th. Yeah, like I said, if you can do these things and show me that you're capable of handling these things and it's important to you, then maybe after 3 or 4 months, I can let you out of sanctions court. You can go back to regular reporting and business. Okay, excellent. Any questions? All right, sign right there. Ready to go. Have a good day. You too.
Each of those you need to call.
Yes, let's go ahead. Have you already called them?
No, sir. All of them.
Yeah, let's call Nix. Let's call Hazel. Yeah, let's go ahead and call all of them. Let's go ahead and call all of them. Hang on, where's the Godwin? Yes. Yeah, good. Yeah, go ahead and call all of them. Yeah. All right, that does conclude the criminal dockets. I'm gonna have the names of those who did not appear today. Samantha Carol Nix did not appear. Joseph Ryan Hazel did not appear. And James Wesley Godwin did not appear. I'm gonna have their names called loudly distinctly 3 times in the courthouse. Yeah, I've already signed this. So, yeah, here, I'll put that on the record if you want. All right, Samantha Nix, Joseph Hazel, and James Godwin. Their names have all been called loudly distinctly 3 times in the courthouse with no response. The court is going to issue judgment nisi. The court issues the judgment nisi for Samantha Nix. The court is going to take the nisi under advisement for Mr. James Wesley Godwin. Tomorrow. Court's going to take Mr. Godwin's nisi under advisement until 4 p.m. tomorrow to allow the attorney to provide any kind of medical documentation regarding Mr. Godwin's alleged hospitalization. And then court is going to take the nisi for Joseph Ryan Hazel under advisement until 4 p.m. today for Mr. Manning. All right, that concludes this morning's criminal docket. Court's going to stand in recess until 1:30 for the afternoon.